Courtney? Good, all right. Time is 8:30. Call the commission meeting to order. Commissioner Butler will do the invocation.
Thank you, Mr. Chair. Lord, you bring us together to do the work of this great state. Thank you for all that you've given us, the many blessings, the blessings of freedom, blessing to call ourselves Texans, the responsibility that we have to administer fairly, the rules that we make and decide on behalf of those that come before us. Please let us be ever mindful that we serve the citizens of this great state. We ask you to protect us as we go back to our homes at the end of this day. And we thankful for all that you've given us. In your holy name we pray. Amen.
Okay, Courtney, so will you call roll, please?
Yes, sir. Chairman Rick Figueroa,
Here.
Vice Chairman Tom Butler,
Here.
Dr. Ray Callis, Dr. Gary Wesson.
Here.
Commissioner Nora Castaneda.
Here.
Commissioner Lori Hyde.
Here.
Commissioner Sujit Raksham.
Present.
We have a quorum.
Thank you, Courtney. Okay, can I get a motion to excuse Dr. Callis?
So moved.
Second? Second. All in favor, say aye.
Aye.
Opposed? Motion carries. Courtney, 0 public comments.
0 public comment.
All right. Commissioners, I'm going to adjust the agenda here. I'm going to move item M for an executive session, particularly during the executive session. Do we have to present yet?
The two of us.
Okay, come on up. Chris, come on. John, that's cool. It's not a company, okay, it's not a bad seat. We got another two over here. Okay. We got another two over here.
How's this?
Typically, it's not a good seat, but it's a good seat. So, you're in politics, you know that. All right, Courtney, go ahead.
I don't know if Commissioner Butler would like to say a word before we get started. So,
Chairman, do you mind?
No, absolutely, go ahead.
So, ladies and gentlemen, I have the honor today of being with some very esteemed folks that I respect tremendously. People from my hometown, and it's not often I get to do that. And so I'd like to introduce Christian Boniet,
Beyond it.
and Brenda Hellier, the chancellor of San Jacinto. When I was going there, it was called junior college. I spent 6 years trying to get a 2-year degree. You laugh, and I was going to school at night.
I don't think that was a problem. But we'll move on.
I worked construction during the day and went to school at night, and they were there for me. And I'm honored to serve on the board of trustees of the foundation board at San Jacinto College, trying to raise money for scholarships. And so I'm honored to introduce y'all, and thank you so much for being here today.
Commissioner Dockstrom, did you want to say something?
Well, Dr. Eller, thank you. I think what you have done on this one with the innovation right there, working with Courtney, it kind of brought up a new perspective for us. And it would be, if I don't quote someone's name, John Moon Sr., your trustee. I think he's a dear friend for both of us and several of right there. And I want to give the credit to him for challenging us that we can do something. And here we are. And thank you, Courtney, to understand. And I think as we go on, we'll have a couple of questions to work on to see what we have done and how this pilot transpired and helped the students that you are educating and how they're coming to the workforce. So we would like to hear your perspective.
Floor is yours. Go ahead.
all right, you want me to start? Yeah, well, let me just say, when this was brought to us, the intent was to smooth the line from completion of training to licensure so that the students of San Jac could go to work more quickly. And Steve Bruno led on the executive staff, but there were a number of divisions that were involved in this. I will tell you that our experience with Dr. Hellier and Christian and the staff at San Jacinto has been very good. It is much harder to make certain changes with technology and process than what it often appears on the surface. But we've been able to make some great strides, and for the purpose of making sure students finish with everything they need to go to work, whether they need to pay off a loan or even if the school was free, we know that they have rent and bills. And so I really appreciated the staff taking the charge to do everything we can through this pilot, and that San Jac was so good to work with us. And we would adjust when we needed to. We might have a plan and we would need to adjust that, and everybody was very flexible and kept the ultimate goal in mind. So thank you for that. And we look forward to continuing these next couple of semesters with the pilot.
If I could just kind of paint the big picture, so that, because you talked about some of the pieces. So what it was a program, and I have to thank the chairman, because the chairman said, just keep me in the loop as we go along. Spoke with him very, very early on. He said, this is where we need to be. And he said, just let me know, and let me know if you have any problems. So thank you. We did keep him in the loop. Thank goodness we had very few problems, and that's directly attributable to both the staff here at the agency, which we've come to expect, right? We just say, oh, work this problem out, and they come back with a solution. It's ridiculous that y'all do it, and you do it so well. Same with San Jacinto College. So the big picture is, we wanted students to be able to graduate in just a couple of programs, because this is a pilot program, cosmetology, was it massage and barber?
Yes.
Massage and barber. So your final exam would be your licensing exam. What a brilliant idea. And I've been on this commission 12 years, and it took me 12 years to think of it. And so, but it's such a common sense thing, right? Your final exam could be your licensing exam. You go to work, you get your diploma, you go to work that afternoon. What a great idea. And so that's what the big picture was. And it's a very simple thing, but it's very hard to execute. So
Well, thank you. First, I want to thank both of the commissioners for really leading this, and you mentioned John Moon. So I want to thank you for postponing our last testimony. John passed away right before your last commission meeting. And I have to tell you, one of the last conversations I had with him was he called me about this program. So this was very dear to his heart, and he was very passionate about this. So we are really excited and delighted about how the program has turned out and what the potential could be. And I do want to also, you know Christian from our team. Christian's all over the place. Everybody seems to know him. And but this was really him taking and working with your group and then working with our team. And so I want to thank Christian for his leadership on this also. But I want to kind of talk to you about the results of the program, what's happened. We've had a pilot in May, and then we've had a smaller one in August, just where we've done the testing. So I'll give you some results about that. So the model was around cosmetology, barbering, aesthetics, manicurist, and massage therapy. And what you heard Courtney talk about were some of the barriers. And for us, what we saw was limited site availability, childcare burdens, travel to get to those sites. Our students, Tom's not too much different than a lot of our students. They're working students. Cost and then scheduling delays were also the other issues. And so we really wanted to look at how do we take away some of those barriers and those wraparound services we know we've got at our campuses. So after receiving the approval in February, and we had an agreement that went to our board of trustees, so they too were aware, and they were like, figure this out, just keep us updated on things, and that's how our board operates. So by late March, we were really working through the logistics and finalizing proctors and evaluators who needed to be part of this. And so we got our proctors and evaluators trained. And the proctors were really the ones who were there as the written test was being done. Those were broad across the campuses. We had deans, we had other faculty in other areas, making sure how the test was administered. And then from the subject evaluators, they were from the different campuses. So we have cosmetology in these programs at 2 different campuses. And so we made sure we switched off to make sure faculty so they're north and south campuses. So faculty who were evaluating north students came from south and vice versa, because we didn't want them to be familiar with that. So we navigated even a regional internet disruption. There was a total internet outage on one of the testing days, which we never can plan for that. But in the end, we ended up being able to reschedule it, and the team really got everything coordinated around that. But this was about a true partnership. So how this worked, they completed the TDLR licensing exam on campus immediately following their semester. And so all students took the written exam, And the students in cosmetology operator, esthetician, and manicurist programs were also required to take the practical exam if they had passed the written. And so the massage therapy students are the only ones that only have a written exam. So again, test was administered by proctors. We had the subject matter experts, and then TDL granted us authority to use our own practical exam as the official licensing. And we also had a generous donor who helped us pay for the student testing fees because they still needed to pay those fees for PSI. And I'll explain that to you in a bit.
When did you have them take the exam?
In May. So
Like in May, and we were able to still get the results.
Yeah. And it's really cool. I think you're gonna get some pictures.
On
You've
the
got-
back of your
It's on the
executive summary.
And you
Those
can
pictures.
see pictures of, they took the exam, we got the results at commencement. They got their diploma, and Courtney was at the end of the line giving them their license. So it was very, very exciting and really cool for the students. But more importantly, got them to work, and I'll tell you about some examples there. So we began the pilot in May. We had 198 students that were in those programs. Again, cosmetology, aesthetics, nail technology, and massage therapy. So we had 128 students who completed all of the licensure requirements. That meant they met the programmed hours, they passed the written exam, they passed the practical exam where that was applicable. So of those 128 who passed, 113 were officially licensed, and so that was 88%. The remaining 15 students, 13 of them didn't submit their licensure documents in time, and 2 of them were under the age of 18, so they couldn't get their license yet. So we have dual credit programs, which are high school programs, and 2 of those students hadn't turned 18 by the time they graduated. So they were ready for as soon as their birthday hit in the summer.
But then again, it's almost 100%.
Yeah. So the ones who didn't complete, 4 students were absent on the day of the test, and then 35 were removed from the pilot due to scheduling. Some of them had already elected to test at TDL, others TDLR sites. And then there were also dual credit students. And the dual credit students came from Galena Park and Sheldon ISDs. And those ISDs had already coordinated with test sites for the testing, so they weren't in our pilot. In the future, we're going to look at how we include them. And the remainder didn't have enough instructional hours. So how did our results compare to your statewide results? And I've got some data. And the bottom line of it is that the Sanjack students performed statewide better than all the statewide averages across all of the exam categories. Most notably, we had 100% pass rate on the practical exam. But on the written exam, I just want to give you some data. The state averages for the various areas that we tested ranged from 52% in cosmetology and manicurists to 64% in massage therapy. So those are the state averages. The written exam pass rate for the Sanjack pilot students ranged from 71% to 100%. And in one area, I think it was about 43 points higher at the Sanjack side. And that was the written. So all of the results confirm that testing students on site in a familiar setting where they have the supports and shortly after instruction leads to higher success rates and a reduced attrition. So one of the examples I want to give you is those students who received their diplomas. We had a massage therapy student. She graduated Friday night. She got her license that night. And on Saturday, she started her job at Massage Envy. So employed right away and immediately able to get into the workforce. So I mentioned we did an August pilot. So we have a smaller program of students who graduate in August. We had, and this just happened 2 weeks ago, at our North Campus, we had a manicurist group that was graduating. It's again, small, 9 students, and 8 of them passed the exam, and so they're now licensed. That is a 89% pass rate. And at the South Campus, we had aesthetics, And 13 of the students were eligible to take the test. 11 passed it, which is an 85%, and they all passed the practical exam. So now each of them is licensed. So in total, there were 19 more students in August. And again, making sure what we learned from May that we tried to improve even with the smaller group, the process around that. So resources, pilot took a significant resources, both financial and personnel. We had to really make sure we were delivering the test, and how we were controlling it. And we had about 60 people that were involved in various aspects of that. The scale, we're really going to have to look at that. I also mentioned financial. So we had a scholarship in our San Jacinto College Foundation, which is a 501c3. It was donated from a faculty member, David Waters. He had been with a faculty member for about 30 years. He retired, created a scholarship, and then passed away shortly after that. And so we used all the funds in that scholarship, which is around $10,500 for the fees to pay for those students. In the summer, we used a federal grant. We had a Title V federal grant to pay the fees, which was around $1,200. We'll need to look at resources for May, but that is something that we need to continue to figure out. And then I've mentioned the 60 employees. So those employees, they were doing project management. We had IT involved. We had administrators. Our testing center leads were helping us to make sure how we were proctoring. We had the faculty raters. We had, then we also had instructional design experts, making sure how everything was clearly aligned. And they worked, Courtney's team was available all the time. They had a lot of calls to make sure how things were going to work. PSI had staff involved also to make sure how this was all going to align. So what's next? Our next pilot will be, or part of this will be in December. We anticipate 200 students that will be ready in these programs for testing. And so that'll be our largest cycle to date. And then that'll give us a more comprehensive look at how this model could work. But I really think it's important to look at what the results are already. I mean, 132 licenses issued right away, right when these students completed. Those students got into the workforce, and that high percentage. I mean, the 100% practical test rate is pretty impressive, but even the written exams.
Could you,
Give me, let her go and finish. I want to get.
Okay. So what really made the difference, though, is delivering it on campus during your academic term. They had already been part of the system. They were ready. You used aligned. It was aligned with our coursework. They had the wraparound services. I mean, they had the childcare there. They weren't traveling. They were in our labs. It's a salon fully equipped. They had everything they needed there. And then they also had just the strong partnership that was established and making sure we took away any other barriers for them. I think we can really continue to accelerate the success and getting these students into the workforce. I'm going to end just again by thanking Courtney, thanking all of you. I want to also thank Steve Bruno and then the rest of the staff here. It took a whole team and the PSI. I mentioned Christian, but then everybody else at San Jack. They know so much of the details of this. We have meetings and they get into the details and I'm like, okay, I just need it here. And again, thank you.
Okay. Yeah, thank you, guys. I got it. I know the commissioner, know they're loaded for a lot of questions.
Okay, am I ready for it?
Well, no, we're not ready, so we got a lot of cases, but what I would like to tell you this on behalf of the commission and the commissioners that work so hard, experience, thank you for what you've done. Thank you for what you've done and the efforts that it magnifies the existence of what we do. And so you have been able to do that well. So we appreciate it. I know, Steve, I've already turned you on to HCC. So with Miguel San Juan, so I know we're going to be working. So this is just the beginning. So I will commit this to you that there will be a focus from the commission point of view to get this into existence at the fullest level. support. I love the wraparound services that are available from childcare to whatever it needs to get this where it needs to be. So we will be focused on it. So I want to thank you for that. And I'm sure we're going to go into executive session. We'll have a break if you won't mind staying. That way the commissioners can visit with you after executive session,
Okay,
one-on-one, and kind of get their 2 cents in with you guys. That'd be great.
okay.
Is that fair? Is that fair?
Can I ask a couple of questions briefly?
Okay, well, I was gonna wait till after executive, but go ahead.
Well, Dr. Keller, I think, what concerns me is two things. One, you have about 200 students coming up in the fall. And I hate to say that you got to go and find a donor or federal grant or whatever it is. What can we do to get your 200 students? Because obviously you're spending a lot of your resources, like 68, as you mentioned, 60 of your folks right there. There has to be a way, Courtney, probably you all need to look into seeing if we can work out something where they don't have to pay or something, because they're also spending their resources right there. So I think, probably look into that one, but I'll have more questions down the line.
Okay,
Oh, sure. I told you they're right. This is great. It's all exciting. They're right, chomping at the bit. All right. Thank you. If you don't
Okay.
mind hanging around.
We'll hang
next
around.
session will be about 30 minutes, and we'll allow the commission to come back, give some time to talk.
okay, thank you.
Thank you so much. Thanks, Christian. All right, we're going to items D. Commissioners will now go into executive session to consult with our attorney under section 551.071, subsection 1 and 551.071, subsection 2 and 551.074 from the government code. Time is 8:52. After the executive session, we'll take a break and come back here. Doug, we're looking at about 30.
Yeah, 30 to 40 minutes.
So let's say 9:30, come back here at 9:35. 9:35. Okay. Now, Courtney? Doug? Okay. The time is 9:50. If anyone, we're gonna go to, wait, sorry, check this. There are no action items of the executive session. Item E. I need approval for the minutes, Commissioner.
I move to accept minutes.
All in favor, say aye. Opposed?
Chair.
Motion carries.
Chair, can I be present, not voting? I wasn't here.
Okay, that's fine.
Thank you.
Item G, which is contested cases, and I'm gonna read some instructions real quick on this. If anyone's here and appearing in person for the case today, we'll call you up when your case is announced. We'll hear from the prosecutor first and from you responding. You'll have opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak with up to a possible 3-minute rebuttal if needed. Please understand the commission can only hear and consider information that is in the record and when the case was heard. So you must limit your comments to those matters that were presented in the SO hearing. So we're gonna go to item G1, which is the healing hands massage and Morgan Cumming. I don't have a paper on these speakers.
Okay, I'll make sure I get them to fill
Okay.
it now.
Did you guys sign the form?
No.
No, they told me to get you agenda, so.
If you don't mind, go ahead and grab a seat. Okay. If you don't mind, just grab, we'll grab a seat. Before you leave, gentlemen, just if you don't mind, we'll need you to fill out. Okay. Okay, did you understand the instructions directly? Perfect. Okay. Let me go ahead.
Good morning, Commissioners. My name is Morgan Cumming, and I'm a prosecutor with the Enforcement Division. I recommend you accept the Administrative Law Judge's proposal for decision and assess Healing Hands Massage Institute LLC, the respondent, an administrative penalty of $3,000 for failing to terminate Mr. Vincent J. Garcia's enrollment since he failed to attend the school for a period of more than 30 school days without a documented leave of absence, and for failing to maintain an album or database of each student permit, including a photo of each enrolled student. While this may appear as a simple minor record-keeping violations case, proper and accurate record-keeping is a vital responsibility of schools, for it ensures students receive the education they pay for, which allows them to be eligible to take their exams and qualify for licensure. These mandatory record-keeping requirements allow the department to verify the students are receiving the education they paid for. If schools do not maintain accurate records in compliance with the law and rules, students who have expended time and money may not obtain their license. On November 19, 2021, Donald Don Moorfield III performed an on-site inspection of the respondent's school. Among the violations identified by the inspector, Mr. Moorfield, the ALJ found the department proved 2 violations in that the school failed to terminate Mr. Vicente Garcia's enrollment after he missed 30 days of school without documented leave of absence, and failed to maintain an album or database of each student permit, including a photo of each enrolled student. The respondent argued the inspection was inappropriate due to a rule requiring that the owner or designated contact person must be available during scheduled inspections by the department, because Mr. Andrew Alexander, as the alleged designated contact, was not present and was unavailable during the unannounced inspection. The department argued 1, inspections are not limited by the unavailability of an owner or designated person, and 2, the department, when conducting an unannounced inspection, may rely on the personnel at the school to determine who is the designated contact person. The administrative law judge concluded the absence of Mr. Alexander at the unannounced inspection does not prevent the department from seeking administrative penalties for performing unannounced inspections. The ALJ interpreted the rule as creating an obligation for the school to ensure the availability of an owner or designated contact person at the time of the inspection. The department recommends you adopt the PFD as written and assess the respondent a $3,000 administrative penalty for failing to terminate a student's enrollment, who failed to attend school for a period of more than 30 school days, and for failing to maintain an album or database of each student permit, including a photo of the student.
Thank you. Any questions, Commissioners?
Council,
Do you have a question?
yes.
Yeah.
What's the rule?
The
The rule on the inspection that the institutes or schools are supposed to maintain the records? Is that fair assessment?
which
What I'm asking is, are the schools supposed to maintain the records as part of the rule? Or acceptable? Okay, that's part of the rule. Okay, so here our issue is simply that the rule was that our inspector went and we couldn't find that. Is that fair?
Correct.
Okay, thank you, thank you.
All right, any other questions? No. Okay. I don't have your name, so I'm sorry.
That's all right. I'll introduce myself. Mr. Chairman and Commissioners, my name is Roger Borgelt. I'm an attorney representing Healing Hands Massage Institute. Mr. Andrew Alexander, who's the sole owner and proprietor and runs Healing Hands, is here with me. So he's not planning on speaking, but if you have questions that I can't answer, he may need to step in. First and foremost, it's unfortunate that we're here under these circumstances, and I'll get into that for a variety of reasons. My client has a long history of licensure with this agency, feels that he has been over the years very supportive of this agency, even helpful in some instances in providing information and resources to help with the regulation of massage.
I'm gonna object. That's not inside the record.
I'm gonna give you a little bit of background just because I don't have it, but I understand what you're saying. But yeah, she wants you, we do need to continue with what was in the SOA here. if you don't mind.
That's fine, that's fine. So, I think what we're dealing with here primarily is just an issue of a communication breakdown. My client, basically had all of the records and the information that he's being cited for not having. Had he been present at the time of the inspection, he would have been able to provide all of that information. I think that there's an issue with the interpretation that the ALJ makes of this law, basically saying that the inspection can be done at any time because the designated person is responsible and only one person at a time can be designated. This massage institute operates 88 hours per week. So that interpretation would basically require Mr. Alexander, because there can only be one designated person, to be present for that entire 88 hours every week. That's simply not a possibility. So I think the issue of either that rule or the interpretation of it needs to be addressed if we're actually going to allow inspections looking for specific records at any time that the business is open. I do understand the need for spot inspections, but somehow that needs to be addressed because it would be impossible to have one person there who, if the law only allows one designated person to be there for that entire 88 hours. We feel like these were paperwork issues. Again, there are issues also with the auditing because the student that is being cited for not dismissing or removing the roles was actually just auditing classes, and the procedure of the commission for actually how it is that people auditing classes are supposed to document their attendance is not clear to us. It's never been made clear to us in terms of the documentation of audit hours. Mr. Alexander's been told that they do not want audit hours entered into the PALMS or the commission system, but they have not explained actually how to document audit hours. This particular student was rescued basically from another school and retrained to meet the standards. And so that was all done on the school's dime, not the student's dime. He did go on to graduate, pass the exam in the first attempt, and got his
This
license.
isn't in the record either.
Is-
It's not in the record. Regarding the student's outcome, it's not in the record.
Yes, it's evidence.
It's his testimony. It is in the record.
It is in the record. It not, Doug, can you check on that if you don't mind? But yeah, go ahead.
Anyway, we're now here having gone through this entire legal process, and we still don't really have any guidance as to how to handle audit hours or how they're supposed to be documented. Then in terms of the student permit database, Healing Hands has a proprietary software system that stores all the records, including student permits, including the photographs. That system has been in place since the origin of the school, which was far before student permits were even required. The law specifically allows the use of a database, but again, exactly how that database is configured has not been defined. Mr. Alexander absolutely could have at any instant provided any records that would have been necessary to request from that database. The band that was in charge that day could not. That's simply the fact of where they were on that particular day. And finally, we feel like we should have not gone straight to enforcement, but given an opportunity to comply under Government Code 2006.003, because that provision of the code allows licensees, small businesses, which HHS certainly is, an opportunity to comply before enforcement is initiated. That never happened. He was simply cited for these things and taken directly to enforcement. And had he been given an opportunity to show that he could comply, he would have been able to show that. So I think that it's not fair to take him directly to enforcement when the agency did not comply with 2006.003. There simply was no opportunity given for him to show that he could. So I'll stop there, but I really do think that this was primarily a communication issue, and it's unfortunate that he's being sanctioned for things that he either did not do or could have easily explained had he been there.
Thank you. But commissioners, questions?
Yes, sir. Counsel, let me ask you a question. You said that your client works for 88 hours or something, the school runs for 88 hours.
School is open for 88 hours.
Do you expect our inspectors to work 88 hours or knock, knock, we're coming in, so get your record straight or something? Is that how it works?
I think I'll let him address that.
So the law allows them to inspect at any point in time that we are open.
Okay, thank you. Thank you. So your records were not clean at that particular time, or you or your designate or whatever it is, that's an issue right here, correct?
So it's not that the records weren't complete, it's the person that was there didn't have access to the records. I was there at the time.
So just to respond, the ALJ did take his testimony into account. He did provide evidence of his database. The earliest evidence of the database existing was dated from 2023. The inspection happened in November of 2021. He did not submit any evidence of that database existing prior to 2023. And regarding to a person auditing a class, that's not something that TDLR does. He had a student permit. So as having a student permit and being enrolled, he should have been dropped within 30 days. And it's so that students don't have to pay for classes that they're no longer engaging in. It's to protect the student and the school from getting funds that the student shouldn't have to pay if the student has in essence stopped coming to class, is dropped out.
Yeah.
So there's two things.
Let's take this.
Couple seconds.
So the rules do allow for one unannounced visit per year, right? Have you provided the records that we have requested in the interim before it went to SOA here?
The records so anything that was requested by TDLR, we did provide.
The answer is no.
Those particular dates, and if that particular, I guess the commission has.
Yeah, for the dates that are pertinent. So that's a factual question. You say yes, she says no. That's something the judge would have taken into consideration, and they ruled against you in that regard.
I don't believe there was ever an opportunity provided to him to provide records after the inspection. That's part of the problem. I don't want to go outside the record, but when we sent out what started this, what's called a notice of alleged violation, he has the opportunity to provide those materials to me to review. He never did.
You satisfied with that?
Yeah, I think so. So what is the maximum, what is the fine amount that we're, 3,000 that we're arguing over? Okay.
So the maximum is 5. Any other questions?
No.
Commissioner, how you good?
Yeah, just to be clear, the incident happened in 21, we said, and the database was not present even up until 23.
The evidence presented by the respondent that he submitted as an exhibit, the earliest it was 2023. He did not provide evidence of the existence of that database as an exhibit and for November 2021.
That's actually not true. And there's actually exhibits in there that show that we have things going back before even student permits are required. And that is part of the exhibits.
Do you have those exhibits?
And I think the ALJ findings state that 21. And somewhere there's a miscommunication. I think I'm ready whenever you are.
Go ahead, what do you, give me the finding.
So it's respondent exhibit number 7. It's in the PFD where it goes into what exhibit
Yeah,
number 7
okay.
is, and that's the database portion. There are other records, but we're a database or an album. The earliest evidence presented by the respondent was 2023.
Okay, did testify that it existed from the school's inception.
Well, no, there's other ones there where we show the first permits that were issued back in 2019. And let me see if I can find the exhibits.
The judge didn't find that. So, no, we can only contain what was it, so there. Okay, what else? Any others? Okay, I'll take a motion, Commissioner.
Mr. Chair, I move to accept the PFD fine of $3,000.
Is there a second?
Second.
Okay, all in favor, say aye.
Aye.
Opposed? All right, motion carries. You might have another options. I think the staff will get you, you will have another option. Staff will get you followed up together, okay? All right, thank you for your time, comments. Thank you.
Thank you.
Item number 2, Pat and Nicole Burns. For you to. Thank you, guys. Mr. Pat? I don't have, okay, so that's your okay. Louis? Lecter, you're the counsel? Yes, sir. Okay. Do you understand the instructions I read earlier? Okay. Go ahead, Ms. Burns.
Good morning, Commissioners. My name is Nicole Burns, and I'm a prosecutor with the Anti-Human Trafficking Division. We recommend that you accept the administrative law judge's proposal for decision and revoke respondent Alexander E. Paddock's massage therapist license and impose a $5,000 administrative fine for the count of engaging in sexual contact with a client during a massage session. Complainant LG had a membership with Hand and Stone and received monthly or semi-monthly massages from a variety of therapists at their Bee Cave and South Austin locations since 2018. LG received her first massage from the respondent on June 9th of 2022 and received her second massage with the respondent on August 26, 2022. During the second massage, respondent touched LG's external genitalia, penetrated her labia with his fingers, and massaged her breasts without consent. LG testified that to ensure she was able to leave the spa safely, she attempted to act in a manner consistent with her normal behavior during the checkout process. She did not notify employees of what had occurred and left a tip consistent with her usual practice. After LG returned home, she canceled all of her upcoming massage sessions. The following day, she reported the incident to police. And as a result of the incident, LG has experienced nightmares and nausea and engaged in therapy. Respondent denied the allegations. He argued LG's credibility was undermined by her lack of immediate response and reporting after the June and August massages. Department investigator Katerina Avila testified that based on her training and experience, LG's behavior after the assault was consistent with behaviors of other sexual assault victims. Specifically, investigator Avila said victims are often reluctant to give full accounts of incidents due to re-traumatization. They attempt to behave normally during the checkout, including leaving a tip and maintaining composure until they are in a safe space. And they delay reporting incidents to police. The department sought to revoke respondent's massage therapy license and impose a $10,000 administrative fine for 2 violations of the enforcement plan by committing a sexual assault during a massage session and also for touching the breast of the complainant without consent. The ALJ found no motivation for LG to falsify the incident and found that LG's account was more credible than the respondent's denials. The ALJ determined multiple methods of sexual contact during one massage session constituted a single violation of the enforcement plan, and therefore found that respondent engaged in one act of sexual contact, and the ALJ recommended license revocation and a $5,000 administrative penalty. The department requests the commission uphold the proposal for decision as written.
Any questions from Ms. Burns? Okay. Mr. Lecter.
Thank you. Good morning. We would ask that you look at the entire record and determine that the judge abused her discretion in the findings. Ms. Avila, the department's expert or witness, was objected to give an opinion, because she is not a qualified expert under Daubert Rule 703 and 704, Texas Rules of Evidence. Yet it was allowed into the record all of the factors that Ms. Burns, right?
Yes.
Yes, alluded to that are in the PFD. But there is no indication that the investigator had the training, education, and experience to opine about such. In the PFD, the judge draws a conclusion that both sides presented reasonable accounts of the incident, but the preponderance of the evidence went with the complainant because of those factors, and hence that was one of the reasons why she tended to coincide or write the PFD favorable to the complainant. In the record, there are several exhibits. Exhibit number 3 indicates the amount of massages that this complainant had gone through, and it's replete with maybe 30, 50 visits over the last 4 years. Yet she goes on to say that after her first encounter with Mr. Paddock, that she didn't know that it was untoward to have her privates touched in the way that she alleged, and she had to Google it in order to determine if that was the appropriate rule. That just doesn't make sense. And I'll point out some things in the record that the complainant stated that are just inconsistent with the practice of massage therapy. For instance, on page 10, there's a complaint that she had both legs massaged at once. The way the diaper draping works, one leg would be wrapped in the draping, and the other leg would be free for work. If the complainant had indeed, as she did, received that many massages, she would have known that to have both legs exposed at once and have one hand on one and one hand on the other was inconsistent massage therapy practice. Also, she does talk about the draping, but doesn't indicate that the draping itself, if used appropriately, wouldn't allow for the genitalia to be exposed and touched in the way that she asserted in the complaint. It just makes no sense. And if she had really indeed been to, which she has been to this many appointments, it would be some indication that the use of the diaper draping was inconsistent with what she had experienced before. She alleged that staff wasn't alerted and that she told her brother, but there was no indication that any of the other evidence that she spoke of was corroborated by any other source. And also, for some reason, the record is complete that respondent did not practice massage therapy after he was notified of the complaint by the police department. And the judge did not determine this to be a mitigating factor in an effort to remediate his efforts and, wait for the commission to decide upon this and the judge. And why it wasn't determined a mitigating factor, it's not explained for in the PFD. And also, why she talks in the PFD, the judge, that the administrative penalty of $5,000 would somehow deter this kind of future behavior. Well, if he's revoked, I'm not sure how that really deters future behavior. It just seems unduly punitive. Looking at the record in total, it just doesn't make sense that the findings were drawn and concluded on the way they were by the ALJ. Objections to the evidence were properly put forward, yet it seems to be a completely one-sided opinion. I would ask that you look at the fact that respondent has practiced as a massage therapist for 14 years, has no criminal history other than a speeding ticket or traffic ticket, had no other incidents with a complaint from anybody, and we estimate that based on his work history, he's performed about 12,500 massages over the course of his career. And this is the first complaint, and it came 3 years ago, and he hasn't worked due to his own decision since that time. This has been riveting for him and his family, and inconsistent with the character of his work performance and his job. The police department concluded that they could not make a decision, and the DA rejected prosecution. Yet, here we are today, where the judge clearly exceeded her authority and abused her discretion in analyzing this case from a criminal perspective and concluded that he violated the Texas Penal Code, which is outside her authority and discretion. Therefore, we ask that the department look at this case and either decide to remediate, give Mr. Paddock a chance to remediate this case through continuing education or some other, or table this so we can further look at the evidence and make a rationalized decision than just looking at the PFD alone. Use the entire record to ask yourself if you think this makes sense or if there was an abuse of discretion on the part of the judge. And that his procedural and substantive due process rights were violated. We would argue that this just doesn't make sense.
Is that it?
Yes.
Okay, all right. Commissioner, I'll remind you that, and Doug, check me on this one, if you don't mind, findings of facts are not necessarily negotiable, but how we approach this and what we can come to conclusion are. So, we agreed on that. So we'll make sure if you need help in any way on this, make sure you get counsel. All right, questions?
Counsel, what's the role of the DA? Is it criminal nature or civil nature?
The DA's office is responsible for criminal offenses, and obviously criminal cases have a much higher burden of proof than we do with the defense.
So all this went through a judge, a qualified judge, correct? ALJ? So-
Administrative judge, administrative judge.
Yes,
So whatever evidence business is all between all the judges, lawyers, you all figured it out, correct?
yes, Commissioners.
And basically outcome here, what I look at is the outcome is the PFD.
Yes,
And as a matter of fact, what it is a PFD is pretty much, we got to make a decision based on the PFD. Is that a fair assessment?
it is.
Thank you.
Can I respond to that, please?
Sure.
Sure. In a criminal case, what I was alluding to is the DA, district attorney, rejected the charge, saying that he didn't find sufficient evidence. So there was no record from a judge or the police department other than the offense report or the incident reports which said there is not enough evidence to pursue this matter. So that's from a criminal standpoint.
Any questions?
Counsel, I understand what you're saying this one for, when you mentioned about the preponderance of evidence, in terms of criminal, it's a higher statute, you got to meet. But here, it's a behavioral issue right there. And the license, occupational license is based on a behavioral issue right there. So you need to understand where we are stuck right there.
Oh, I understand. And, I
Thank you.
think I was alluding to the fact that to indict him, you only need a burden of probable cause, which is much less than a preponderance of the evidence. So if they had indeed wanted to investigate further, they could have indicted with a grand jury, which is burden of probable cause, and then gathered more evidence.
Okay, speak for them. Okay, I'm done.
So you're not working right now, is that, you haven't worked since this incident?
Correct.
And how long was that?
It's been almost 3 years now, a little over.
So you don't do any work?
I've been a stay-at-home father since that time. I had a 2-month-old when the alleged incident occurred, and I've been taking care of him this whole time.
And you do have a current CV that, does it list that prior business meant? Would you?
My resume did not have Hand to the Stone on it when I had submitted that because I just didn't update my resume when my previous lawyer.
I didn't address that because it wasn't in the record.
I think I read it.
The CV was in the record.
Oh.
Was it in the
I
record?
think it was a CV that we applied to hand done with, so
Okay.
of course it wasn't on it. But yes, his updated CV was not.
Okay.
Thank you.
I don't have any more questions.
No? Yeah. Okay. All right, I'll take a motion.
Chair, I think we got to be consistent with what the findings we've been getting from ALJ. Based on that, I move to accept the ALJ's, the PFD as recommended.
Is there a second? Motion fails to the second. Is there another motion?
Move that we remand to enforcement for next steps.
Probated sentence.
Yeah, do we have a probation type?
Well, okay, thank you. Doug Jennings, General Counsel, TDLR. Yeah, if we could have a discussion about what that expectation is, if you're remanding to enforcement for an agreed order, would that be for perhaps a probated suspension? Would there be an administrative penalty still attached that you'd like to pursue? What probated suspension? What sort of term would you are you seeking to probate the suspension? I think it could be, a year, it could be 3 years. And so think about that and discuss that please amongst yourselves, and what, if there are additional requirements you'd like to impose. For example, council mentioned continuing education courses. Basically, when we pursue an agreed disposition, as much direction as we can get from you would be helpful.
Just stand up. Okay, so you're welcome to add some scripted part of it, whether you want it to be education or anything else. I want to contain it to your motion. I don't want it to be a discussion. So that motion.
So after 1 year, we come back.
Well, that would be your choice to make as to how long the probate suspension would last.
Within your motion.
Right, and just as a little refresher, if you revoked.
She wants a term of 1 year.
Okay.
Okay.
I hear you.
Remanded back to you for probation or suspended sentence or suspended.
A probated suspension of the.
Probated suspension
with
for
the
1 year.
Suspension running 1 year.
Okay,
To be
just
clear,
let
that
me
would
make sure.
allow the respondent
Hang on.
to continue, to hold a license to continue to work, but there would be some conditions that would be placed in that agreed order with the respondent. And if we're unable to, if the department is unable to
Make an agreement,
get
it'll come
an
back to
agreement,
us.
then we can bring that case
Okay.
back to you.
Are you okay with that? Okay, Tom?
Mr. Jennings, what is just the normal term of a massage license? Is it
2 years.
2 years?
Mr. Weston?
No, I just,
Okay.
he explained.
All right, so you got the motion. Is there a second?
Second.
Second. All those in favor say aye.
Aye.
Opposed?
Oppose.
Opposed. Motion carries. All right, we'll give, you'll have questions. Staff will give you. Thank you for your time. Thank you, Counselor.
Thank you.
Ms. Burns. Item 3, Deputy Church, Jessica Cotto. Jessica Cotto, good to see you.
Morning, Chairman. Good to see you too. Commissioners?
Okay, go ahead. I'm sorry, go ahead.
You-
Apologize.
No problem. Okay. Good morning, Commissioners. My name is Jessica Hurtado. I'm a prosecutor in the Enforcement Division. The ALJ recommends that you revoke Ebony Nicole Upchurch's manicurist license. I ask that you adopt the PFD as written. In March 2024, respondent pled guilty to promoting prostitution, a felony offense. The court deferred adjudicating her and placed her on community supervision for 2 years. According to the police report in 2020, a victim made an outcry to the police stating that respondent began arranging for the victim to work as a prostitute sometime in 2016 when the victim was 17 years old. According to the victim, the respondent was responsible for posting illicit ads and scheduling appointments. Respondent arranged for the sale of sexual services at a variety of different locations. One of these locations appeared to be a legitimate salon with pedicure chairs and nail stations, while prostitution would be occurring in the back. Respondent was 37 years old when the offense occurred. In June 2024, the respondent submitted her renewal application and answered no to the criminal history question. At the hearing, respondent testified that the victim's accusations were false, but that she agreed to the plea deal because she was facing life in prison. She also testified that she answered no on a renewal application because she had not yet been convicted. Promotion of prostitution is a guideline crime involving prohibited sexual conduct that is directly related to the cosmetology profession. According to the guidelines, holding a cosmetology license would provide the opportunity to commit similar offenses in the future, and that is exactly what occurred in this case. Respondent used the cover of a legitimate salon to conceal her illicit activities. Regarding her false answer on the renewal application, the ALJ notes that the question asks about both convictions and deferred adjudications, and concludes that the respondent's explanation for answering no strains credulity. The ALJ analyzes the Chapter 53 factors and notes the respondent was a grown adult when the offense occurred, which was less than 5 years ago. And while the respondent is in compliance with the terms of her supervision, she offered no letters of recommendation from members of the community or other evidence of her fitness to hold a license. Therefore, the ALJ concludes that the commission may treat her deferred adjudication as a conviction for purposes of licensing and recommends that you revoke her manicurist license. I ask that you adopt the PFD as written, and I'm available to answer your questions. Thank you.
Any questions, Commissioner?
How many salons?
You said various.
I don't recall off the top of my head. There was at least one, but there are also hotel rooms, other locations.
Any other questions? I'll take a motion.
Make a motion that we adopt the PFD as recommended.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you.
Thank you, Chairman, Commissioners.
Laura Palmer.
Thank you, Mr. Cotto.
Bill Brown, item 4, Commissioners. Go ahead.
Good morning, Commissioners. My name is Rebecca Scove-Burkhalter. I'm one of the senior prosecutors for the Enforcement Division. I'm here to present this case to you today. The case was presented before SOA by former TDLR prosecutor Alyssa Collinsworth Stewart, but I'll be presenting it on her behalf. The hearing was held April 2nd, 2025 before Administrative Law Judge Lacey. The case was the result of a department sting operation from 2022 where respondent Philip C. Brown provided a bid to an undercover department investigator to install electrical plugs, switches, and perform other electrical work. Later, respondent submitted a written bid to offer those electrical services, which came to $7,315. The department investigator testified the work required an electrician's license. Respondent was not licensed. The department requested an administrative penalty of $3,000. There was testimony that respondent had not stopped offering electrical services since the sting and continued to offer electrical services up to March 2025. And the judge found, quote unquote, no evidence of corrective actions taken. The administrative law judge upheld the department's proposed $3,000 penalty. There were several exceptions filed after the case to correct clerical errors. The department would ask that you accept the proposal for decision with the $3,000 penalty with the minor minor clerical errors already corrected as recommended by the judge.
Any questions? Take a motion.
So moved to accept the PFD with modifications of page 4, finding fact number 7, conclusion of law number 1, and conclusion of law number 3.
It will state. All right, is there a second? Second. All in favor, say aye.
Aye.
Opposed? Motion carries.
Thank you, Commissioner.
All right. Motions for rehearing. Accepted.
Yes.
And Ms. Nguyen? And Ms. Ho? Okay. Commissioners, Ms. Ho is Ms. Nguyen's daughter. She'll be interpreting. Just want to prosecutor, if you don't mind, just giving her time to catch up. Okay?
Sure.
Okay. Do you understand the instructions? Let me read them to you real quick. If anyone here is appearing for a motion for rehearing We'll call your case up. We'll hear from the general counsel first. Sorry, general counsel, I apologize. And then we'll hear from you. You'll have an opportunity to speak. Please make sure you speak clearly and state your name. Okay.
Good morning, Mr. Chairman and Commissioners. Cassie Sofstead, Assistant General Counsel. We have one motion for rehearing today regarding the matter of Hong T. Wen, DBA Rose Nail Spot. Respondent's motion is the result of a default order where the department assessed administrative penalties against respondent in the amount of $8,000 based on respondent's gross malpractice arising from a client contracting an infection after receiving services at respondent's establishment.
Okay, let's hold on.
Yep.
She understands?
Yes.
Do you understand?
No, she got that part.
Okay.
Yeah.
Okay, I don't mind slowing this down.
Yes, sir.
Okay, so no rush. Go ahead.
Okay, and for sanitation cleaning record violations. Although respondent's motion for rehearing did not contest service of the notice of alleged violation or default order, I confirmed that NOAB was delivered to respondent's business address of record on March 28, 2025, and the default order was delivered on June 25th, 2025. In respondent's motion for rehearing, she states the department's NOAB contains material factual errors. Specifically, respondent asserts that the finding she did not maintain complete cleaning records is inaccurate.
Yes.
Additionally,
You need time?
And I have brought records.
Okay,
Just-
okay. I want to make sure she understands.
She understood.
Okay,
So I explained everything.
okay.
Additionally, she argues the department failed to establish the alleged client infection was caused by conditions at her premises as opposed to other potential sources. I reviewed the file in addition to the cleaning records provided in support of respondent's motion. In short, the cleaning records do not show compliance with the applicable rule as she has asserted, and she has not provided any evidence to support her assertion that the infection was not caused by conditions at her premises. Based on the information available to me, we recommend you deny Hong T. Wen, DBA Rose Nail Spots motion for rehearing. I'm happy to answer any questions you have.
Any questions, Commissioner? Okay.
So the person that filed, to say that she contracts,
Infection?
the infections at my salons, that didn't happen because she walked in there, it's her service, and she was fine in the beginning. She has already had some sort of leg down on her toes, and she was fine until when it's ready to pay, she didn't want it to pay. It's causing troubles at the salons. And then she walked out of there. I guess she reported as, I don't know what she did after that when she gets home. And she reported, and then when the inspector came out, he didn't give us anything when he was done with the inspections. He didn't give us any notice. He didn't even email to me. I usually get them by email every time the inspector come out for like yearly inspections. But I didn't get any notice. Not only that, he didn't make any comments about anything. He even compliments that the store is well kept. And I don't know, all of that he wrote down there, it's just a slap on my face. Like literally, I can have my staff that was working at the time he came to testify that he didn't say anything like that. If it was, wouldn't you think the inspector would have said something? Oh yeah, okay, this is what happened, this is why I came out, and that's, you know, you shouldn't be leaving that there. And about the cleaning sheets, I don't think he read it right, because and my mom did it, and I think she should have done it daily, but she didn't. She organized them by employees. So it shouldn't be done like that, but I didn't notice that how she kept it. So every day the employees would walk in. If you do a pedicure, you would search for your name on your tab and then write it down. So I guess the inspector didn't know how to read it. So he was flipping, he's like, whoa, okay, so there's all this name and it's, I mean, they wrote down on daily, so, but that's, I would like to know if you deny my motions, can you at least show me like, where is it that he did come to this, like, he did come like, but anything that he wrote needs there? Like, when he comes, should I get something signed or?
Excuse me, Doug Jennings, General Counsel, TDLR. Chairman, I just want to just kind of reset a little bit, which is, here we have a motion for rehearing.
Right.
Where we've had a default order issued. Really the question before us, the respondent is contesting the allegations in the NOAB, right?
Right.
And in the default order. That, we've gone through the enforcement process.
Right.
Ms. Sapstead demonstrated to you that service of that default order in NOAB was completed in a manner consistent with our rules. While, one of the reasons I didn't interrupt the respondent is, while I don't believe that the issue on the table before you is whether or not the inspector
Did the job or not?
did the
Just if
job,
Did we miss
we
something?
have an order that Ms. Sapstead has reviewed and is found to be without error. I just want to recenter it, if you will. So I'll hand it back to the parties. Thank you.
So the motion that you're offering is that if we miss something in here, we're not relitigating the issue. We're just seeing if there was something that we missed in that hearing. That's what the motion is. So I just want to make sure you understand what your motion is. Does that make sense? Is there something that we missed during the process that you want to bring up that we need to rehear the issue?
She said.
Yes, ma'am.
So, okay, I want to make sure what it is. I'm going to help you out here a little bit, right? So what we're saying is if there's something you have, or there's something that was overlooked during the process of the case, when the SOA hearing was heard,
Yes, sir.
right? SOA that y'all went to, if there was something that would want us to send it back and look at it, that's what you need to bring up right now.
And there was no hearing in this.
There was no,
instance.
it was just
It's
a default order. Okay, so
One clarifying question, and I have to ask this. I've noticed that you were offering to translate on behalf of your mother. Has she, is she following this discussion? I haven't seen you translating, so I'm
Oh,
just.
and because when we're discussing what I had already explained to her and showing her everything when I submitted.
But you're representing her.
Yes.
Basically.
Yes.
Okay, we'll make that clear. Just put that for the record.
Okay, thank you.
She's representing her.
And you're the owner? My mom is the owner.
So, Commissioner, let me give you questions. I'll ask you questions on this one. But go ahead. Any questions? And Mr. You go ahead. Any Commissioner questions?
Gotta ask you a question. I understand issues she may had or something, a lesson learned. If someone is bad, take a picture, keep a record of that one for future. I think, it's very clear where we got to be within our guidelines. Our guidelines are what they are. And we got a rule based on those guidelines. Thank you, Chair.
Okay. Any other questions?
So was there, I'll ask our person, was there anything that were missed that she said she had but wasn't in the original default?
No, based on my review, everything that was contained within our NOAB was supported by evidence. And without getting too much into the nitty gritty, because we're not here to relitigate, what she provided in support of her motion didn't help the allegations anyways, if that makes sense. So
It wouldn't help her.
no, it still didn't support her assertion that in fact her clean records were sufficient. So again, stepping the line here, since
Right,
we're not relitigating this, but
I guess the question stands, is there anything we're missing? Any documentation?
And that's important, right, Mr. Chair, because, the gears of the state they crush the individuals sometimes. We just want to make sure that everybody's interests are being protected. Thank you.
yeah, and I would just like to point out that at this point, she, as you guys know, she's not out of options now, so she has the right of appeal and this. So.
Any other questions? Okay, I'll take a motion.
I make a motion that we deny the motion for rehearing.
All right, is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. And so, when staff will give you have some other options, but I want to make sure you understand what those options are, okay? So we'll make sure coordinating staff follows up with you both to make sure you understand, okay?
Thank you.
Okay, commissioners, we are in, item H, and I'm sorry, take that. Item I. Thunderbird. How are you doing, Mr. Thunderbird?
Understand you're under pressure, so I'll make this brief. Chairman, Commissioners.
Make sure you
Oh,
speak up.
oh, I'm sorry. Good morning, Chairman, Commissioners. I'm Christopher Funderburg, the Assistant General Counsel assigned to the Laser Hair Program. Item I consists of amendments to the administrative rules governing that profession. The proposed amendments to the rules took shape during the 4-year rule review of Chapter 118. The notice of intent to review was published on September 3rd, 2021, and no public comments were received in response. On January 25th, 2022, the Commission readopted Chapter 118 without changes. The amendments requesting the Commission adopt today are a result of the combined efforts of TDLR staff to reorganize and streamline all of Chapter 118. The recommendations include changes to consolidate the existing rules, reorganize provisions by subject matter, eliminate duplicative provisions, and improve clarity by applying plain language principles. These proposed rules were published in the Texas Register May 30th, 2025. The department did not receive any comments during the 30-day public comment period, which closed June 30th, 2025. I recommend that the Commission adopt these proposed amendments to become effective August 21st.
Thank you, Mr. Pepper. Any questions? I'll take a motion. So move. Is there a second? All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you. Mr. Burkhalter, item J. Texas Lottery and Charitable Bingo. I have a feeling we're gonna be hearing about this.
Just a little bit.
Maybe a little bit.
Good morning, Commissioners. I'm Derek Burkhalter, Assistant General Counsel. I also want to give credit to my colleague, Robert Reyes, who's here. He did a lot of work on this project as well, so kudos to him. So these are emergency rules that we're bringing to you. This is part of the transfer of the lottery and bingo programs to TDLR. Transfer, as you know, was done by Senate Bill 3070. It takes effect on September 1st. Part of what the bill does is it requires us to establish a lottery advisory committee and a bingo advisory committee. And those committees are both supposed to start meeting quarterly as soon as the program transfers. And so that's why there's kind of an emergency nature to these rules, to adopt them on fewer than 30 days notice, because we have to get those committees set up and so they can start meeting. We will follow up with the standard rulemaking to establish those same provisions in permanent rule. We'll be bringing those to you at a later meeting. So these rules basically establish the member composition, the appointment procedures, the terms, and the meeting requirements for the committees. So we just ask your adoption of these, and they would take effect 20 days after filing, which we expect we would file today. So the emergency rules would remain in effect until January 8th of 2026. As I said, we expect that we'll be bringing the standard rules to you to follow up on these, so that we won't need the emergency rules anymore at that. So we are recommending adoption, as I said, on an emergency basis, to be effective 20 days after filing.
Which I'll make sure addresses it. This is after the September 1 time period.
Yes, that'll be about September 10th is when they will become effective, but we can go ahead and appoint the board members in the meantime.
Right.
So they'll be ready.
But not prior to September 1.
Correct.
Right. I just want to make sure that we're clear.
Well, we can do things preparatory for that date, and so this may fall into that category. So we don't necessarily need to wait until these are in effect. We can go ahead and begin having those conversations. And, you'd have to make the appointments at a public meeting, so.
Right. Which we're not gonna have till September anyway.
Right, exactly.
Right, people. You good with that, Doug?
Absolutely.
Okay, all right, questions?
Yes, sir. Council's SB 3070 specifically says the agency can do the integration. But currently there are 3 commissioners duly appointed by the Senate. Their existence is till 31st August. I understand the nature of this one. My issue is there is a commission already right now. And I understand that you want to have this one. Can we get this advisory board in October by passing whatever it is on September 4th? Is there a is there going to be a meeting between now, September 4th, till October?
A meeting of the advisory committee? We haven't planned any specific dates yet, so it's possible that a meeting will fall within that time period.
So with the staff going in during the transition period, what is happening? It can continue to do this one. What is the necessity or urgency of having an advisory board in the next 30 days?
Because the board has to meet quarterly, and so we have to get them set up and get them do our introductory training and all those things in time to have a quarterly meeting.
Fair enough, but I think, it can happen in October or November, right?
So the quarter would be from September 1st until December 1st?
Yeah, that's a quarter right there. They can meet sometime right there. The only reason is there's a duly elected body out right there, which is the lottery commission. They don't cease to exist, and we, in my opinion, unless until the council can tell y'all the legal guys.
So Doug, why don't you give a little bit of background, that way there's clarification.
Okay, happy to do that. Doug Jennings, General Counsel, TDLR. Commissioner Dropstrom, as you mentioned, the transfer, and as Mr. Burkhalter mentioned, the transfer is effective September 1st. And so what we are doing here is, like Mr. Burkhalter mentioned, is we're taking those steps to ensure that the transition happens without delay. Keep in mind that even, assuming that you adopt the emergency rules today and that we file them, they will not be effective until September 10th. And so those advisory boards will not exist until after the effective date of the transfer. So no one's going to be displaced. We just want to make sure that those bodies are in place so that it can begin doing their work. So we can start making appointments at the September 4th meeting if possible. Just to, we want to make sure this transition goes seamlessly and smoothly. And these are just key components to that.
Yep. Well, especially effective date being September 1, which is under our leadership. So we'll have to have control of that at that time.
Well, in other words, what I hear, Chair, is, in 3 days or 2 days, the staff has vetted the advisory board. Is that fair assessment?
No procedure has been done yet. No.
Okay.
We have not begun accepting applications.
I guess your note's pointed. We can go back to if you want to vote against, it's fine. I'm just saying that your note's pointed. All right, any other questions?
Thank you. You made my answer easy. I thought I'd be getting to the point.
What's the point? I'm sorry, what's the point?
The point was, I think they'll convince me about it, and you already made my point right there. So you said I'll vote no. That's what you wanted me. So I'll do that one. I don't have a problem.
All right. Any further questions?
If I may, Mr. Chair. So
Sure.
I think, let me kind of square that circle or circle the square. I think, Commissioner Drugstrom makes some valid points about us not stepping on any toes until the first. But we do have to prepare, even having said that. Nothing would be official until after September 1st. So I think we're in the clear, but I think those are valid points on each side. I appreciate the work that you've done, Derek. You used to be a young man. You seem to have aged in the last month. Don't know what's doing that. Maybe the charitable bingo. So I do appreciate the work that the agency has put into this program. It's a tough one for all of us, right? So, thank you.
Okay, good comments, Commissioner. Anything else? Okay, I'll take a motion.
So moved.
There's a second?
Second.
All in favor, say aye.
Aye.
Opposed?
No, I say aye.
Okay.
For the hard work.
Do love you, John. I do love you. Motion carried. Thank you. Appreciate your time. All right. Going to item K, Midlock, Mr. Midlock.
Good morning, Commissioners. And if you don't mind, we can actually probably combine A and L because it's essentially the same thing.
You never look better than you look right now.
Again, my name is John Millick. I'm the Chief Prosecutor here for TDLR. And I'm bringing you the update and the new penalty matrix from the auctioneer program and the electrical vehicle charging stations. Just a couple of highlights. We took the auctioneer penalty matrix to the advisory board on June 26th, which was adopted unanimously. We, along with our other existing programs, updated it, standardized it, added any changes in the rules or statute that had occurred since the last time we updated it. With the electrical vehicle charging station, since we don't have an advisory board for that, we actually used the existing work group that we did when that program came on board, got the buyout from those members, and that happened in April 2nd. So if you approve, I would like to adopt B. I would ask for a motion for you guys to adopt both of these so that we can use these and publish these in the Texas Register.
Can I ask you a question?
Absolutely, go ahead.
Um,
Sure.
And this may be a bigger question for Courtney, so please, where are we on the electrical vehicle charging stations? I just kind of want, can we just kind of big picture, what's going on there? It may not be the appropriate time, but.
No, I think
we're talking about it, so.
Well,
it's been a while since we've heard it.
Right, yeah, so we are accepting complaints as of March of 25, so I don't think we have any complaints coming in, which is always a good thing. So this is just another step on the enforcement process. So we're just waiting for people to get licensed, these stations to come up as they come in, kind of like fuel pumps, get those licenses in, and then if any issue do occur, waiting for those complaints to come in, but we haven't really seen those yet from at least the enforcement perspective.
We have the stickers, the same stickers that say, if you have a complaint, contact Courtney Arbor. This is her cell number.
Maybe not that far, but yes.
They do explain how to report a concern. They look very similar to the decals on the fuel pumps. They're a different color. Happy to get one for you so that you can see what those look like. And if you'd like some information at the next meeting about the number of licensees and the activities so far, we can prepare that for you or get it out to you via email.
How do we promote it to the state? You know, I buy a car and I'm
I think we do through a lot of our social medias and through our under the umbrellas and like our email blast out that people register, industry groups. Try to
so when I buy a car, I'm not buying a car, but if I were to buy a car, they would tell me, oh, you can charge.
I think that may be part of the process when you purchase that.
Any other questions?
Yes, sir.
Yes, sir.
On these EV chargers, we going to have, what's the inspection? How often they do the inspection? Every 2 years?
I'm not certain of the timeline for the EV
It's
inspections.
all right.
Why don't we put together a one-pager on the status of this project with some of those fundamentals and we'll get it out to you.
Also on the stickers, if there is a time frame as an expiration or something, can that be put so that we can educate the public that, hey, the inspection was done January and it expires, something like that?
Because of the nature of these industry, these facilities being built and the decal being placed, they don't have a date on them. The intent of that decal on any fuel pump or the EV charger is to report to us when there's a problem that they would like to make us aware of so that we can go out and do an inspection.
So we don't really go and inspect if, whatever the kilowatt hour, whatever it's supposed to give the charging, we don't do any of those.
Doug Jennings, General Counsel, I can give you a little more info. We have a rule that we are not conducting those on-site inspections, regular on-site inspections until March of next year.
Okay.
However, we are conducting inspections and investigations pursuant to complaints.
Okay.
And so if we have a place, for example, that has a number of violations, that person, may not get a regular inspection, but may be inspected to ensure that they remain in compliance.
I think, Courtney, that a summary for them would be great, and then give them some guidelines. That's great information. We just run out to
And I
March.
did receive clarification. It's an annual renewal requirement. But we'll get you a stat sheet on the.
Cheat sheet, thank you.
And then again, I guess the draft is right here. The electrical inspector, right there. Penalties.
The penalties, yes.
Yes. Any other questions? All right, good motion.
So moved.
Second.
Both of them.
Motion is second, right, I guess. Okay, now, second, all in favor, say aye.
Aye.
Opposed? Motion carries, thank you.
Thank you.
Okay, done, Brandy.
Mr. Johnson's gonna come up and, facilitate the discussion.
This internal audit.
Commissioners, for the record, Charles Johnson, Deputy General Counsel, and in keeping with the theme of this meeting,
I was never a young man.
We're funny. Continue on.
But I tried. The agenda item is in response to an open solicitation. And because it's open solicitation, there'll be very limited discussion about the details of the and the recommendation, because if there is a change, which doesn't agree with it, and there are issues that we have to litigate at some point, we want to keep the record clean in terms of what a respondent possibly raised in litigation. And so you have in your packets the content, which consists of the solicitation itself, the recommendation to award, the dollar value of the contract, and this is for a internal auditor to conduct inspection audits of the commission program, IT infrastructure for the next 4 years. The first term is for 1 year with the opportunity to renew for additional terms. Now, the contract also has a provision in it, and this is public information, that there's a early termination provision in it. So we can either we enter a contract today, we can at some point exercise the option to re-solicitation anywhere from the do an initial term, or we can refuse to renew the contract and issue a new solicitation. So the commission's options are open in terms of future action in respect to this particular transaction. And so the work group met twice to go over the recommendations, to review the proposals, and to bring back to you their recommendation. And so I'm not going to step on their presentation, but overall, this was the sequence of events, and I would ask that you adopt the recommendation as recommended in your materials, and yield to Commissioner Butler to report on the work group activities.
Go ahead, indulgence, Mr. Chair. Thank you so much, Mr. Johnson. The Audit Finance Work Group met twice, October 7th and October 15th, to discuss the internal audit service contract and the recommendation for award, which was handled in agenda item N. So we had some discussion, and I will make a motion to accept the recommendation that was forwarded by the agency. But I do want to bring up some discussion, Mr. Chair. And that is, we've had this same audit firm, Weaver, for 8 years. I think it's probably time to get some different eyes on it, but because of the time constraints and because the lottery was thrust upon us in the last couple of months, I think we need to start moving forward. We cannot afford to not have an audit firm. But with the complexity of the charitable bingo and the lottery, I think it's probably time in the not too distant future to have a different set of eyes. Now, I have really enjoyed Weaver, and not to say that they won't be with us continuing forward, but I do think, it's probably good. Certainly in my industry, every 3 or 4 years, we have to find a new auditor, and we have audits every quarter, different audits, IT audits, what we call a SCAR audit, a BSA audit, ACH audit, and then every 2 years, the feds come in and examine. So it's good to have a different set of eyes. Having said that, Mr. Chair, if there's no discussion, I'd like to make the motion.
I want you to give everybody a chance to, because I'm sure there might be some comments, but thank you. Yes, I'll stand down on that motion. Any other comments?
Yes, sir. Vice Chair Butler, you basically told that in your industry, 3 to 4 years, that's what constant audit. I understand that one. This time excuse is not acceptable. The reason, I've been here 2 years. Every time I see audit right here on the computer, okay? And today, when I hear that there were solicitations, there's only one proposal. Okay, I don't see any other proposals right there. This is a recurring issue in terms of the audit right there. I understand for 8 years, it's been the same thing, but public entities, most of them do every 5 years or 6 years or something. So the excuse of, oh, we won't have an audit or something, That's unacceptable. I think, we can do better. Maybe for one time we can change. I know Weaver does a good job, don't get me wrong, okay? But maybe for 1 year, if we want to see something different, fresh set of eyes always are good right there. Because again, there may be a different folks working on this, but it's the same company, the practices are the same. So I'm really concerned about the time frame.
I think those are all valid concerns, and I share them. Um, I'm of two minds here, and one of them is Weaver knows our DNA. Weaver knows our processes. Weaver has been with us through this journey. We probably had 600,000 licenses when Weaver started. We're up to 1 million now, and the legislature keeps giving us new licensees because we do a good job of bringing those people in. So that's one mind that I have, is that Weaver has seen us grow and they've seen us integrate different license programs into the fabric that we are. So in an odd way, they can see what lottery brings to us, and they can help, and they can see the differences and make sure that they become part of us instead of us becoming part of them. I like that aspect of the continuity. The flip side is we need CPAs and analysts that can look at something and say, this is odd, right? This is odd. We don't want them getting too comfortable with staff and that sort of thing. But I would just caution everybody. Any failing of finding a new auditor should rest solely on my shoulders as chairman of the audit group. The staff has done an incredible job, as they always do, right? And so, again, it's the comfort level that I have with Weaver. And so, but I also brought up, going forward, we need a different set of eyes. And this may be the time to start looking. Again, we have to enter into a contract because there are things that we have to do. So my responsibility is to make sure that those timelines get done, the audits of all of these different things. And I do have a comfort level with Weaver. Not to say that will continue forever. I think it's probably time to start looking, simply because of what I've already stated. But I think those are probably all the comments that I have. I would like to thank the staff for the time that it does take. And we put this out for bids for everybody. We just kind of have a criteria, and for some reason they kind of floated to the top. And if you'd like to help define that criteria, I think that would be a good thing. A different set of eyes as well, right? I've been on audit for a long time, probably the whole 12 years I've been here. So maybe it's time for a different set of eyes as well, to maybe help define that criteria. So maybe different firms percolate to the top.
Rewrite the criteria?
I'm sorry?
Rewrite the criteria?
You don't throw it all out.
Right.
There's certain things that you have to do.
Update,
Yeah. Okay.
See, I'm not questioning the process or something, probably they'll come up number one, because every city I work with, every 5 years, they change the auditor for a purpose right there.
Absolutely.
And this is where time is not an essence. Let's get it done correct. If you need to do something, let's take a back step and do it the right thing rather than rush the judgment. Because I do know that one, they'll do a fantastic job right there.
Sure.
But for our comfortness, okay, I would like to see a change for a year or something, whatever it is. Maybe the number 2 guy, I don't know who it is because I haven't seen any of the scorings or nothing.
Sure.
But I would like to see a change because it's not fair when staff gets comfortable and everything is the same practice. People may change, the big company, they can change other people, but the procedures are still the same right there.
Sure. Yeah, I can tell you that those are great comments. And even in my world, in the credit union world, if we have an auditor that does something, but they find that they're out of their depth in a particular subset of what they're auditing, they'll bring in another auditor. And so that's something that we may consider as well down the road, right? If there is a need, as we start digesting the Texas lottery and charitable bingo, that maybe there's a need for specialization that we hadn't considered. And staff will bring that to us and we'll start considering it at that point. But that may be a way of bringing in somebody else as well, right? So,
well, I think, in my perspective, I think probably we're going to be looking into an audit for them the next time, the bingo. I think we can't equate both of them. But I would request you to think about, I know you have a recommendation right there, to see if we can take the next guy, whoever it is, because I have no clue who it is.
Sure.
As the fresh set of eyes for 1 year, give a chance and see if they can perform or not perform. And then again, solicit whatever you want to, because at least, we can see that, hey, we never had someone for continuous 8 years or 12 years right there.
Yes.
That's the only reason I'm requesting if you want to reconsider your position right there.
I don't think I'll reconsider it, but I will take that into consideration and maybe ask staff to see if there is a place where maybe another audit firm can come in and start to see what our processes are and what we do, and maybe in that regard, bring somebody in, but time is what it is. We start the lottery program September 1st. And so as apprehensive as I am about a new set of eyes, I'm more apprehensive about having no one watching. And
Yeah,
so-
but we are not auditing lottery right now on this one because we don't have any issue. We're auditing only TDLR. The question is, we can't be combining both of them because
I
we
know what
can't
you're saying,
combine.
but starting September 1st.
Yeah, but that's different aspect. Even if we were, whatever it is, the firm you recommend, if they're auditing, they're going to be auditing only the first, right now, what we have.
I don't know that I would agree with that. I think starting September 1st, and I may be wrong, but starting September 1st, it's all part of one bailiwick.
I understand that we're going to be having an audit for lottery starting September.
Initially, we will have two contracts, one specializing in lottery and charitable bingo, and the other for the TDLR traditional programs. Over time, we will have one procurement to manage all of it. But to your point, right now, the procurements were conducted so that we didn't have a gap on September 1 with expertise of those programs and our programs separately.
Yeah.
So there you go. That's it. I think that satisfies both of our needs. We have one audit for lottery and one for TDLR going forward as they integrate. We'll combine it.
Yeah, that's the reason I'm asking you to reconsider if you want. If you're not, we can move on.
Well, thank you. I appreciate it.
Any other comments? Thank you. All right, I'll take a motion.
I'll reurge the motion that we accept Weaver as our auditor contingent.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed?
No.
Okay, motion carries.
Thank you, Commissioner.
Okay, we're going to item O. Commissioner report, Mr. Weston, Lottery Commission.
Well, as just a report on this, as we all know, everything has started moving fast, midsummer, and work groups were set up with TDLR and TLC. Staff have been meeting to ensure a smooth transition on September 1st. We've divided it up into work groups for human resources, finance, information technology, and contracts. And with human resources, preparations underway for the transfer 321.5 FTEs from TLC to TDLR, which has been going very smoothly from what I understand. Regarding finance, progress made to transfer accounts within the treasury from TLC to TDLR, and most of the TLC financials will migrate over on September 1st. And as anything with electronics and transfers, that's been fun. But again, from what I've heard and from yesterday, it's been very smooth. Information technology, again, IT stuff. The teams have successfully created a secure connection between the agency networks with the goal for employees to have access as needed as of September 1st. Contracts regarding security clearances for certain employees at each agency have been cleared and completed. Working on revising the TLC contracts with us. And final legal issues, interagency contracts for the transition have been completed and signed to allow for a seamless transition, working on drafting emergency rules, which we did today, for the transition. But it's all, and hats off to Courtney and her team, and from all the TLC, ones that were moving in here. And we had the chairman and I got to meet with some of them yesterday. Everybody, I think, has a positive feel for this, and we're looking forward to having everything brought in together.
Okay. Any comment or questions for Commissioner Weston?
Yes.
Okay, Commissioner High, midway.
Yeah, reporting on the midwife commission work group that met August 4th. The chair is Commissioner Palace. So, the Midwife Commission Work Group actually met on August 8th to discuss a number of issues relating to the midwife program, including complaints pending and enforcement, advisory board considerations, and possible rule changes for midwifery. Expert witnesses or subject matter experts contract with TDOR to review cases. Since the work group met, 3 additional midwife expert witnesses have entered into contracts with TDLR. Commissioners discussed a number of possible changes to the program, including consulting with physicians, updating client consent forms, and defining high-risk pregnancies that require transfer of care. The statutory scope of midwifery is a normal childbirth defined by rule. Rules could be amended to further define normal, educating licensees on the scope of care, and making it clear when transfer of care is necessary to reduce the chance of poor outcomes. State law prohibits commissioners from adopting a new rule related to the scope of practice or standard of midwifery unless the rule has been proposed by the advisory board. The commission must either adopt the rule as proposed or return the rule to the advisory board for revision. And last is there are 3 vacancies on the advisory board, which are in the process of being filled soon with the goal of scheduling a meeting to discuss rule changes requested by advocates and commissioners.
Thank you, Commissioner High. Any questions for Commissioner High? Enforcement. Mr. Westman.
Well, with that, staff from the Office of Organizational Excellence have been having fun mapping out all of enforcement's complaint process resolution. They call them swim lanes. I'm sure some of y'all might not have heard of that, but we're finding out how to keep this a transition and a smooth for better understanding of each subdivision's role in working on and resolving complaints. The work group is currently identifying redundancies and bottlenecks and has met with team members handling complaints throughout the current process. The focus on the work group currently is to identify opportunities for efficiency, such as streamlining templates used for correspondence. And based on commissioner input, staff are considering better ways to report performance measures, fully capture the breadth of the workload that enforcement handles. Because y'all got to understand that we're getting, complaints every day, and they've been working on ways to really handle that in a smoother fashion. TDLR met with enforcement staff and Texas Commission on Environmental Quality, TCEQ, on August 19th to examine a different process on handling consumer complaints. And this work group meets on a bi-weekly basis with the goal of completing the compliant process improvement project by November of this year. And those are, I think we shortened them down just a few, maybe under an hour, but it's all working in a progressive manner so that we can handle these complaints in a timely manner and fair.
Good. Comment? Yes, sir.
I want to commend Susanna for coming up with the issue, what we are seeing right now. Commissioner Wesson, sorry, we couldn't dive in at the same time during the meetings right there.
I know you were in one and I got in the other one, so yeah, we didn't.
Chair and commissioners, looking at this one, I think, we do have an issue right here in terms of the enforcement. I think staff recognizes that it's about approximately 8,000 complaints in the hopper right now. And the last I heard was it's about a year old. Complaints are being resolved right now. So the pace is pretty much going based on the fact what it is, because the changing staff situations and so on and so forth, outside our preview right there. We got to look into a different one. I think, that's what the meeting with the TCEQ has come up to see how they do it a little bit different compared to what we are doing right there, to see how we can improve the efficiencies with respect to what got to be done right there. So I'm pretty sure, Susanna, you're going to come up with some sort of a mechanism right there. Right now, I do see a bottleneck. Okay. And
can we change that one? I think, the staff got to look into it. I think, y'all may have identified right there what to do it. And hopefully, the next time we'll have a better answer on the numbers right there because simply that 8,000 is unacceptable.
What did you find to be the biggest complaint?
Well, the issue here is this complicated, okay? Just like in a piece of paper, you have so many, as Commissioner Weston pointed out, the swimming lanes. I think somewhere those lanes have to be straightened out and that's what they're trying to figure out.
But are we doing this too slow? Are we getting licenses out too slow?
No, the licenses are nothing right there. This is enforcement. I think the complaint process right there, the complaint driven.
It's in licensing, everybody's getting.
Okay.
Licenses are off the chart right now. I don't know where Charlotte is.
Yeah. I agree. I agree with you. And you two guys, whatever resources you need, let us know. It's on the forefront of my mind. So
I think we got to empower the staff to come up with a plan pretty quickly so that they brief us. I'm pretty sure they already have something internally. Rather than the swim lanes right there, let's streamline it and make it easier so that the staff can do their job. And we don't have the backlog right there. I'm pretty sure they're coming up with something.
we'll keep this on the agenda.
Yes, sir.
Okay. Great job. Great job. Anything else? Okay, anti-human trafficking, Mr. Butler?
Yes, sir, Mr. Chairman. I'll try to make this short, but with the renewed interest in the last few years, both on the federal level and the state level, there's a lot going on. So I'll try to get through it as quickly as possible. But it's just an ultimately important work. The work group met on August 11th. And just a couple of comments real quick. Human trafficking involves these complex and organized networks that target the most vulnerable of individuals. And the TDLR has a very serious commitment to protecting these individuals. The Anti-Human Trafficking Division was launched on March of this year. And since that time, a lot of initiatives have been rolled out, especially the use of the emergency order tool. 49 emergency orders have been issued since the passage of HB 3579, impacting 68 business locations. We continue to partner with different law enforcement agencies. Last week in Northwest Harris County, the department was involved in an investigation that targeted a illicit massage business where a 13-year-old girl was scheduling appointments for what was essentially a commercial sex operation. And so we're staying engaged in all of these things. In September, they'll be starting a virtual law enforcement work group that's statewide with monthly meetings to become a nexus or a center and be part of the conversation that happens in all of the communities statewide. And many of them are affected. My small community has outlawed massage parlors for the next several years, because 3 of them, and that's 25,000 people community. It's a small town. So that gives you some appreciation, I hope, for how pervasive these problems are becoming. TDLR continues to work with the Attorney General's office in using the landlord engagement program to empower legitimate property owners to oust these illicit businesses from their premises. In 2025, TDLR has 4 dedicated anti-trafficking inspectors, and they've conducted 328 risk-based inspections with indicators of human trafficking. That's a 500% increase compared to fiscal year 2024. Now, human trafficking can be found in any legitimate industry, but the industries that we say grace over, they tend to lend themselves to this. Something that we need to consider in the future that becomes a pressing problem. And I know President Trump signed an executive order earlier in the week asking for English to be on government documents. And there's a compelling reason here in Texas for this. A lot of our massage therapy exams are conducted in what we call a simplified Chinese, and that allows an opportunity for exploitation because a lot of our licensees cannot speak fluent English, and that traps them. And so there's some things that we need to start considering there. Offering these exams in Chinese makes these vulnerable Texans a target. Because they can't, because of language barriers, seek help, ask for help, or make outcry. Despite only 5% of Texans being of Asian descent, 62 of those who took the Texas massage examination took it in simplified Chinese.
What's the number?
5% of Texans being Asian descent, 62% taking the simplified Chinese. So it tells you those are indicators of where the future is going to be in sex trafficking. We need to be ahead of that curve. And we need to think of ways to address the problem before it becomes, because if not, we start becoming complicit in this kind of subterranean world of allowing these things to happen. So let's start being proactive in that regard. So we need to consider removing the simplified Chinese. It's our responsibility to make sure that we don't become a harbor in any way for these things. That's it, Mr. Chair.
Any questions?
Yes, sir. Can staff explain that 62%, what are the real, how many people took the test right there? Do you all have those statistics?
We have the numbers, the number of people who've taken all the exams and in what language. We can get that to you. I don't have it in front of me.
So how many of them passed? What's the passing rate of the simplified exam?
We have that also.
Okay. So why don't you all look into this one? Chair, this is pretty important right there, as Commissioner Butler, as Vice Chair Butler.
I think, why don't we do, we get these numbers, I think it's important that we're also not discriminatory in this nature. We don't paint with broad brushes here. So, we need to be aware of what this canary is in front of the coal mine. So, but, when we get the stat, and once you come back to us to make sure what paths would be so that we don't, again, right with broad brush here. We do want to look at an issue that's emerged, as you pointed out.
Okay, the other question is, how many other states offer exams in other languages? Are we the only one, the tech geniuses?
We offer many different exams, as you know, in other languages.
How is that
Other
determined?
states do the same.
How
If
is
you're
that
asking
determined?
specifically about the massage
Yeah,
exam, we are the only state that provides a massage exam in simplified Chinese.
Okay.
It's a common practice for states to offer when they see an interest by a certain industry, by a population, either to charge more for that exam or create an exam. And that's how we came as an agency years ago to creating these other options, language options, so that each licensee wouldn't have to pay an upcharge. But there's a tipping point where you just begin to make it available in that language for the benefit. The data points that you pointed out, Commissioner, are something that we're looking at also, because some of those data points would paint a picture that tells us to look at the administration of that exam, are they all Texas students? We know they are. From which schools are they being referred, and we'll do that.
Okay, thank you. Good. Anything else, Commissioner?
Yes, sir. Thank you, Mr. Chair.
Do we know if we have followed up with, when you order Uber, you know, how they're supposed to, is that still continuing? They have to get educated?
That is correct. Some of the continuing ed for, I believe, all of the Uber drivers, just someone that's expert on this program, there is a component in the continuing ed for human trafficking for several of our programs. Actually, the legislature has required those in some of the programs.
And what about the driverless Ubers? I wonder if that's going to be an issue.
I'm sorry, what's the question?
The driverless
Uber.
Ubers. I wonder if that's going to be another issue. I mean, it just seems like,
I don't
okay.
think so. We regulate it.
It's more about helping them to understand,
No,
to find
understood.
signs of human trafficking in riders, but as far as the driver list, can you?
Yeah, I just would like to answer Commissioner Castaneda's question. And yes, the transportation network companies are required to provide annual human trafficking training to their drivers. So that's not really, that is an obligation on the companies, not necessarily on the drivers. I'm sorry, what was the second question about?
I was just asking, it's just off the top of my head, if they realize that maybe Uber drivers are getting educated. What about now that they start to call the Uberless drivers?
You know, in Austin, basically you have those driverless cars right there. No trafficking right there. You can sit in and go, I guess.
Right, there's no requirement when we have driverless vehicles.
I'm not sure where we're going with this.
Yeah.
Let me set it down just. Any other questions about? All right.
Yeah,
Yes, sir.
are we also offering a continuing education in other languages? That, you know, for massage, I think once you get your license, I think look into that one too, the continuing education, because sometimes it becomes a little bit tricky. Because I did hear from someone that they can get CUs for a lot cheaper than the aspect right there.
Interesting. Okay. You got that, Court? Anything else? Good questions. All right, legislative review, Commissioner, Dr. Ron.
Okay. Chair, I think on this legislative group, Commissioner Callis is the chair, and I'm going to be talking on his behalf today. And Commissioner Hyde and myself, we met on August 16th with the staff. Jeff and Alex did a wonderful presentation of telling us the number of bills which were 555 or had some sort of TDLR stamp. Let's not, Mr. Butler, we're not talking about bingo or lottery, okay? This is just the TDLR 555. Of them, 96 passed and 4 were vetoed by the governor. So we're dealing with 92 of them. So on those 92, the staff have prepared, because typically back earlier days, we don't know what is the status, but they do have a status update on every bill, where it is, when it is supposed to be. So all the steps, what stage it is and when it is going to be brought to us or what got to be done, everything is laid out. So there are about 36 bill implementation teams. It's like computer program, I guess. They're going through one step at a time. I think one of the requests made to the, Jeff and Alex is to keep the ledge involved in the process where we are in, and also to figure out if that is the intent of what we are doing right there. So I think, it's all been worked out as a team right there. So that's what the communications right there. And lastly, I think, with respect to whatever we're going to be seeing the vendors, they're going to create a cheap list so that, we can put it on the back of our pocket right there. So to be careful, whatever happens, when we meet people, so we know who, they may be our friends, but, if they're representing someone, so they're making us aware of all the steps. Okay. So I think I think they explained a lot of bills which were currently in the package right there. One is physicians immunity. I think at the fight I was in, there was last Sunday, there was a physician asking that one, so maybe an advisory or something, they're looking at the bill right there. That could be sent to those physicians, ringside physicians. And solar, so there are a lot of programs right there. And I think the staff would do a good job if you all see what they've been sending us right there, because the schedules and all, that would be good time to see where we are and what we are doing. I don't have anything else unless someone asks a question like how I asked.
Any questions? Any comments? And absolutely, if commissioners, if you want to see the legislative report, let Courtney know, and be happy to get it to you. And as far as the physician immunity, I don't know if it wants to go down to the advisory committee for better sports to take a look at that, to make sure that we address that issue.
Chairman Doug Jennings, General Counsel, that's a bill that just passed.
Right.
And so actually we don't need any rules to implement or anything.
So it's already done.
Yes, and we've sent out some information through our email systems to folks who follow our mailing lists for combative sports to let them know about this change, so we can hopefully, the basis for that law was we need more physicians helping us regulate these events. So I believe some different trade groups are getting that message out too. So we really hope that we'll get more interest from more physicians.
Good. It's rare that happens. That's great. All right. Courtney, item D, anything?
We have just a couple of things under the executive report for today. One, you can be looking in your email, and we'll send you a reminder that your annual training is coming up. So we'll get that to you very soon. We also have a couple of guests here that will be joining our executive team after September 1 from the Texas Lottery Commission, and I wanted to point them out. Sergio Ray is here. Sergio will continue as the interim deputy executive director over lottery and charitable bingo after September 1. And Deanne Renstra is also here. Will carry on. She's currently the special counsel for the Lottery Commission, and she'll carry on into the new fiscal year with us as an interim general counsel over lottery and charitable bingo. Jan Thomas was unable to attend today, but she will be the HR director for the agency effective September 1. I also just want to make note that our governor's advisor, Danny Mitnott, who's a great support to our agency and participates on a lot of our lottery transition meetings, and we're in regular contact with, joined the meeting today in person to meet all of you and to hear some of these updates. So thank you all for being here.
Danny, you buying lunch? The governor buying lunch, so I know. Of course.
And then one other update, we've made a concerted effort to ensure that all of our many advisory boards have an opportunity to meet if they would like to meet. And so Brandy has been spearheading this charge, and Brandy has an update on where we are on the status of that.
Good morning, commissioners. So on July 25th, chairman virtually met with all of the presiding officers of the current advisory boards. The purpose of this meeting was to allow the officers to meet chairman, for him to discuss agency-wide initiatives, solicit a deeper involvement, knowing that they're the experts in their respective industries, and to give them the opportunity to ask some questions. They were very engaged and brought up some important items and concerns. So those primary concerns were some of the boards haven't met in a while. They were wanting to know who their contact was at TDLR for board business and how to submit agenda items for future board meetings. I can tell you that every single one of these has been actively addressed. Out of the 32 boards, committees, councils that we have, 17 of them actually met last year. One is already scheduled and the other 14 are actually in the process of being scheduled as we sit here today. And to give you a bit of history, the prior leadership direction was that we would have meetings only when there was designated board business to take care of. In the last year and a half, we had made it a priority to actually have all the boards to start meeting within 12 to 18 months. And as we started that initiative, legislative session began. In the past, advisory board meetings would go into kind of a moratorium during legislative session, but that was primarily due to the resource constraints and the thought that making rules during session that could change very quickly thereafter would be a challenge due to enacted legislation. But that standard changed, and we did continue to meet and schedule advisory board meetings during legislative session this year. Although I can say it wasn't at like full non-legislative session speed, but we did actually have 5 or 6 board meetings still during legislative session. Chairman committed to the officers that the boards would be meeting at least once per year moving forward, and the advisory board team is actively in the process of achieving that commitment. Like I said earlier, with Western schedule, we've already done. As it relates to the unknown contacts for the advisory board specialist, as we had turnover in that area, we would send out new emails to the advisory board, letting them know who their primary contact was. But we reached out to them again to make sure that they still had that, kind of at the top of their email, and they knew who to get a hold of. And then lastly, in the process of notifying the board members that we were going to be planning meetings, these things were upcoming, and also providing the contact information, we've been able to address the last concern they had of how to get items onto the agenda. And so through those responses, we've actually gotten a lot of information from those board members of items that they do want to discuss in their upcoming meetings. And so those will definitely be put on the agenda as we move forward. So the staff are dedicated to these efforts. We continue to move forward rapidly with this initiative. And additionally, Chairman has committed now to make the meetings with the presiding officers an annual event. So we'll be able to continue to get feedback from them. You remember?
I do.
So we are going to continue this
And
process.
buy them lunch?
What's that?
Buy them lunch, that's what he said, that's what I heard.
Virtually.
Virtually.
Schedule that appropriately. But we'll be doing it probably at the end of July every year, so we get to have this feedback and this time with the presiding officer. So thank you, Chair.
On that note, I know Commissioner Doxron's offered some names, Commissioner Weston. Give those names to Brandy. If you guys are bringing that talent to bear, we will definitely, as long as the slot opens up, we'll put that in place. They are the lifeblood of how we manage a lot, those advisory boards, because I know that, I can't fix my AC to save my life. So, but we know we need to depend on those guys and nutrition as well, and all the others that are coming through. So please give me your names and I'll be happy to submit them and go through them with you. It was a challenge. I think COVID, snow again, caused a lot of challenges in getting these things done, but we've revamped it up. So we're excited about it. They're excited. I will tell you that the chairmen of the advisory boards were just, they were overwhelmed with the opportunity to lean back into this effort. So I'm excited about that, commissioners.
Do you have a handout again of the availability of the boards that are open?
Yes, I can send you that link. Yes, ma'am.
Okay. Anything else, Courtney? Today? Anything else, commissioners?
I got to ask something on the report.
I'm sorry?
On the report, Courtney. I think it's impressive that y'all are tallying about the agency savings. I think y'all are doing some savings. That's pretty good right there. Have you all seen that, Chair and Commissioners? Staff are looking at how do we save money from implementing certain measures right there.
Are you talking about our cost savings list for the Doge list?
Yeah, your Doge list.
All agencies were asked to put together a list of cost saving measures that we could begin taking without cutting to the bone, but reasonable things. And so we did put together a list during legislative session. We were called into the Doge committee and some of the questions were related to that. And so our prep team in HR led by Sharon Pamoya and Luisa Robertson. I think we've got Karen, we've got Deborah, who else is in here working on that? Ernest, the entire Julianne are all working with the different divisions to implement those cost saving measures.
I think, you know.
And keeping list of what it looks like.
Chair, one question I want to call out because typically I do this one on the licensing right there. Happy to report that one. We have about 200 licenses pending as we received the email in less than 3 days.
Good job, Steve.
Charlotte.
I'm sorry.
Heather. Oh, I mean, Heather, sorry.
Heather and the
No,
entire.
that's okay. I'll take all the credit.
No, but that's been a point of contention that we've been able to adjust, so apply the same oil to
The staff, that's on the
entire
you know.
Okay. Anything else? Okay. Sergio. Yes. Welcome to the jungle. Your team is welcomed anytime. Enjoyed our visit. I know the commissioners are gonna be going over there afterwards to get their fingerprints. I would question some of these backgrounds. How are you? Yeah, I would check it twice, that's for sure.
He doesn't need to do it. He can give 6 numbers and I'm done.
Yeah. So we're excited about you guys. We are an amazing agency. We're blessed to have the finest of what Texas offers working here at TDLR. We want you to join those ranks, lean into it. Whatever you need from us, let us know. I know Courtney as well got this well in hand, but we welcome you guys officially in September. But whatever we can do to make you guys in this arena of our well-versed, well-pressure tested system, which has been every year. 10 years I've been here, never a boring year. And the staff has responded. This will not change. We will continue to respond. So whatever we can do, we'll be there for you, okay? All right, staff, commissioners, we will have a meeting September 4th. It'll be limited. It'll start at 10 o'clock. It's a little bit different. I'd also give you full virtual. So I'm gonna let Brock back down. If you want to attend, I'll be here. And so, but it'll be virtual, it'll be limited to the lottery, right? I think the agenda's gonna go out, right, Doug? Okay.
Yes, sir.
So we'll go through that
Pretty
and
thorough.
the next meeting, after that is, do we have?
October 28th is what we're shooting for. I'll be sending an email out to all you today.
Okay.
Okay,
I think I'm
so
doing
the
my
fourth
hair
is
that day.
virtual? Is that what you?
Yes, that's correct.
October 28th, right?
Yes.
Let me check it. I'll double check. We'll have it out for you guys. I know. And also now with the adaptation of lottery and bingo, we're gonna be having more sequential meetings. We're gonna work on those dates. So if there is a date like Mondays are bad or Tuesday bad, let Carnisa know. If you do not, I'm assuming they're all good. Okay, so please let us know if there's certain dates and I'll try to, get the consensus from there. All right?
Thank you.
Anything else?
Yes, sir. I think we heard from Dr. Heller that for the student fees right there, which is, I think, for 200 students, we got to find some mechanism for the fee. I would request executive director to come up with what she can accept as a testing in lieu of the fee right there. That's something I want them to look into it.
Okay.
Because it's coming out from somewhere, the scholarship fund, what she said, that's pretty bad right there. Unless until USI Credit Union can subsidize that one.
I cannot, but I think you meant, it's on.
Yeah.
I think he makes a good point. So what Dr. Hellier alluded to was there's scholarship money, available for these students. And in May, that scholarship money, instead of going to tuition and students, went to testing fees. And it's not, Courtney, please correct me, but it's not coming to the agency, right? It was going to, and my concern is, you have a government entity, a community college. Their whole job is testing, right? And holding standards. And then they have to pay for additional testing. The student does, not the college. But in this case, the college went out and solicited funds that should go to scholarships to pay for the testing fees. And so I want to look at that. I want to decrease any burden or hurdle that it takes for somebody to get a job in Texas. And so please, let's look at that, in a very kind of conscientious way for the poorest of the poor.
Right. So we'll make this a learning lab. We'll put on the agenda, probably not September, but we'll put the October one to see what we can come up with. Great win. Let's make it a bigger win. Okay? I'll take a motion.
I'll make a motion to adjourn.
For second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carried. We're adjourned.